So today I chose to do Epperson versus Arkansas for my case file. And this case was very similar to the Scopes monkey trial case. It had to do with teaching evolution in schools and reasons why it was outlawed for doing that and how these wonderful teachers overcame it. So Epperson was Susan Epperson, and she was a public school teacher who challenged the constitutionality of the anti-evolution statute in Arkansas. So she was new to this school, presented with this textbook that she was supposed to use. This was the mandated textbook, and she's flipping through it, and boom, there's a whole chapter on evolution. Well, this is the textbook she's got to use, but evolution teaching is a little bit illegal in Arkansas. So that leads to a little bit of a dilemma. She's supposed to use this textbook. It says this is what she's got to be teaching her 10th grade biology students. But if she does, then she risks getting fired from her job. So that's a big dilemma. Do you do your job or do you not do your job to keep your job? Serious dilemma there. So Epperson went ahead with the help of one of her students' parents and filed a motion to get the statute void from dismissing her from her position and updating the statute's provisions. So they went to the Chancery Court in Arkansas, and that is the local court, and Chancellor Murray O'Reed said that the statute violated the 14th Amendment, which was upheld by the First Amendment, which is the Freedom of Speech Amendment, and preventing the government from favoring one religion over the other. Now, the 14th Amendment, you can't say you can't have that religion. You can't believe it. You can't learn about it. That's part of the 14th Amendment. Life, liberty, and pursuit of happiness. That includes religion. And the First Amendment is freedom of speech. So, freedom of speech, freedom to teach. So, Arkansas replied with the statute being legal because the state has power over what is taught in the public schools. Okay, states have power over that. Sure, it's been extended to the states. But can you trade in what the state wants for curriculum versus what the 14th Amendment of the U.S. Constitution says? So, I'll be a monkey's uncle. The Epperson case was very reminiscent of the Scopes trial in the content of government not favoring one religion over the other. We've seen this before, 40 years prior. So, in 40 years, with Arkansas adapting to Tennessee's fun little laws, we can see that not a whole lot has changed, and that religion is still very prominent in a lot of these places when it comes to anything to do with teaching. So Arkansas and Mississippi had adopted Tennessee's anti-evolution laws. And the sole reason for their adopting them is because particular religious groups thought that evolutional theory conflicted with the biblical teachings of how man came to be. Was it divine creation? Was it from monkeys? There's a few groups of people that did not want to hear that we came from monkeys. So that is the big thing. The dilemma to teach evolution would be Epperson required to teach her textbook that she was provided by the school for her 10th grade biology class. And mind you, this woman has a master's in zoology, so she knows her stuff about animals, but, she can't teach evolution. And the 14th and First Amendment rights give her the right to teach multiple theories. Now, to not teach is because the chapter of evolution in the textbook and the accompanying lessons would result in her immediate dismissal from being a teacher. Now, those of us that are going to school to be a teacher know that we're not doing all the schooling for nothing. So that's kind of disheartening when the school provides you with a source to teach your students with, and it will end up leading you getting fired if you teach a certain section of it. So it went from court to court. She filed that suit with the Chancery Court. Now, the Chancery Court agreed that the law violated the 14th and First Amendment. Well, Arkansas came back and went, we don't like that decision. The case was then appealed to the Arkansas Supreme Court, where the Arkansas Supreme Court reversed that entire decision from the Chancery Court. So they went back and they went, no, the states can choose whatever curriculum they want, and if they don't want to teach evolution, they don't have to. It stands. But wait, there's more! It just keeps going up and up and up, like a balloon in the air. It went from one Supreme Court to another. And after the Arkansas Supreme Court reversed the decision, stating that the law was legal due to the state's power, Epperson appealed their decision. The U.S. Supreme Court was the next on the line. And so the High Court reversed Arkansas Supreme Court decision that stated the law could not stand because of the violation of the 14th Amendment. Big, big day for this woman here. She did all kinds of things. So after the U.S. Supreme Court decided that Arkansas's law was illegal, they issued a statement to the American public schools that the protection and constitutional freedoms is vital in our schools. They're upholding the amendments. It's our constitutional right. So in the court's reasoning, Justice Fortas stated that our democratic government must remain neutral when it comes to religious theory. Again, 14th Amendment and First Amendment. The U.S. Supreme Court even quoted Thomas Jefferson. Oh, we're looking years back now. All these years. The First Amendment of the Constitution was intended to erect a wall between church and state. What do you know? Can't just base it solely off of religion. So this case was significant, as was the previous case of the Scopes trial 40 years prior, because in that time period, not a whole lot of things had changed when it came to religious views on how we were going to teach science. So with this case, it kind of cemented in place the fact that they can't say we can't teach theories about evolution, about the Big Bang, about any of that. They have now made it so that we can legally teach these theories without promoting one or the other, but students have a right to learn and teachers have a right to teach. And being able to do that is vital to our education system. So the government can't get involved with it. They can't say, no, you can't teach that because we only let you teach this. That's not how it's going to work. If it's available, especially if it's in a textbook that we're supposed to use, we can teach it. So even the Chancery Court was stated that the violation of the First Amendment tends to hinder the quest for knowledge, restrict the freedom to learn, and restrain the freedom to teach. This case was exceptional because this woman didn't just stop and be like, okay, I'm not going to teach it. I'm not going to back down. It doesn't even state that she was one way or the other herself. She just didn't think that she should lose her job over something that she was supposed to teach, but legally could not. So she took this higher and higher and higher until she won. And now we get to learn about Darwin's theory. We get to learn about evolution and the possibilities of all these other theories instead of just the biblical references. And it's partly due to this wonderful woman here. So that is my presentation. Thank you so much for listening.